Are you preparing for your real estate exam? Well, that is great because today we're reviewing some definitions that deal with real property. And so this applies to all 50 states. This is Lily Handy Dominguez coming to you from San Antonio, Texas with YouTube Agent Prep. So let's get ready and review some real estate terms. All right, so we're going to start out with real property. So we're going to define this term. And if you know what it is, you can type the answer on the chat. If not, we'll just keep going to the next. So real property is land and everything permanently attached to it, plus the ownership rights. So real property has 3 levels, right? So you have the surface of the land, underneath the land, and then above, which is the airspace. So underneath the surface would be like wells, septic tanks, all the plumbing, aquifers, when there's wells or water streams. So all that is underneath. On the surface, you have the home, the property that you're having on the surface. It could be commercial, residential, industrial. So that's on the surface. It's all the attachments that are on the surface of the land. And then above the land is the airspace. So if you're in an area where somebody is close to the ocean or on the mountain, and you don't want somebody else to block your view, then you have air rights. And that would limit somebody else in order to build something that is higher and will block your view. So that is real property, different from personal property. So personal property, chattel. So it's kind of like cattle. The cattle moves. If you ever watch Joe Juder on Prep Agent, he talks about chattel, right? And he uses cows. They move. So they move on the land. So chattel moves with the individual, with the owner. It belongs to the owner, right? So it is movable items not attached to real estate, not attached to the home, not attached to the land. Like attached fixtures in a home would be all your power, all your electricity fixtures, all your plumbing fixtures, all that is attached. And if you have a fence on the property that is dug into the land, that is attached. So it has to stay. And so that is like personal property is like furniture or vehicles that are going to go with you. Chattel is another name for it. They move with the they move with the owner. Answers, you can type them in the chat and it'll help you in case you end up getting the answer wrong. Then I can correct you with it. So what are fixtures? Our personal property that becomes real property when permanently attached. So permanently attached would be like electrical fixtures in the house. You change that, or a fence that you permanently attach to the home. There are surface fences that you can remove. Now, plants that are dug into the ground, those are considered fixtures. They're part of the land. If the owner wants to take those plants with them, dig holes, they can't just dig them out and leave big holes. They have to put something else in place of them or cover the hole. Chandeliers, those are fixtures that some individuals have personal attachment to, and it is attached to the home. should they want to take that fixture with them, they'll have to replace it with another one because it is a permanently attached fixture to the home. Trade fixtures. What is a trade fixture? So, you have plumbers, you have contractors, electricians, these are all different types of trades, right? So a trade fixture would be tenant installed items for business, remain personal property. So if someone is leasing a building, an office, and they bring their own fixtures, like for computer stuff, and they happen to have to attach it, or they put subdividers if they're having lots of employees in the office, those are dividers that they can then remove. That's part of their business. A dentist has, dentist chairs for their clients, and doctors or masseurs, they have tables that they do their massaging in. So these fixtures that belong to the business, those are trade fixtures that will be somewhat permanently installed while they're renting the property. However, it is their property, and once their lease expires, they will take them with them. So it remains personal property. Appurtenance. What is an appurtenance? An attachment, right? So it's a right or improvement that transfers with the land. So it's an attachment that's part of the property, yet it's an improvement that transfers with the land, like an easement. If there's a well easement or a septic easement, a driveway easement, these appurtenances, these are attachments that are attached to the property, and they provide a right of use to others. So it is a right. If it's an easement, it provides a use for somebody else to use the driveway on their land. They become the servient party. The person that's using it becomes the dominant party. So access to riverfront, a creek front, an ocean front. So those stay with the property. They transfer with the property when they are recorded. They must be recorded in order to transfer with the property. Bundle of rights. So what kind of rights does an individual have when they own property? They have a whole bundle of them. And those are ownership rights, the right to possess, to control, to enjoy, to exclude, and to dispose. So they possess the whole land, and they get to use it and enjoy it. They control the use of that property. They can allow someone else to come onto the property, but they control the full use of the property. They can exclude others from coming into their property, or exclude certain types of accesses if they don't want to have an easement to someone else. And now, if the easement is recorded, they cannot exclude it. They can dispose of it. They can sell it. They can subdivide it. They can get loans on it. So they have a right to be able to do all that. So those are the bundle of rights: the right to possess, control, enjoy, exclude, and dispose. Encumbrance. What is an encumbrance? It is a claim or limitation affecting the title. So that's kind of uneasy to understand, right? So an encumbrance can be a lien, a loan that's attached to the property, a claim of someone that has a judgment on the property, a mechanical lien. So it limits the conveyance of that property when an owner wants to sell it. So if there's an encumbrance, there's something that is attached to that title that needs to be cleared. Okay, it has a cloud. The title has a cloud, and it needs to be cleared prior to closing. And where do these encumbrances show up? They show up when the title company does a search on the ownership of that title. It can be, as I mentioned, a lien, a mortgage, which is a lien, okay, a judgment, child support, spousal support, or something that is encumberancing, that is coming into their property on the boundary line. So that creates a cloud on their title. If the neighbor has their fence that is further into the owner's property, well, that affects the title, right? The title isn't clear. That boundary has to be adjusted by the owner in order to be able to sell this property. And that creates conflict between property owners. You'd be amazed, okay, at what that can do. So for that issue, it's best to have a survey. An easement, as I just mentioned, easements can be recorded or unrecorded. In order to go with the land, to move with the land as a chattel, they need to be recorded. So it is a legal right to use another's land for a specific purpose. Again, an easement. Now, an easement can be a public easement, the utility easements, power, sewer, water. So it's a way for the utility companies to access those utilities. And that easement belongs to the owner. However, they're giving the right of way to those utility companies to access the property. So it is a legal right to use another's land for a specific purpose. Again, it can be a driveway easement, a well easement where they have a shared well, or they have a shared septic, okay, a shared driveway. A lot of different things that can be used for an easement. It could have access to the edge of a creek, the edge of a river, giving that easement to another person. Certain easements can cancel when the property is sold, but not when they are recorded in the courthouse. An encroachment, that's kind of like the fence being on somebody else's property, and we need to get rid of it, a barn, a shed, things like that. So it is a physical intrusion into another's property. There are sometimes an owner puts up a fence without asking the neighbor, and they end up violating the property line. In order to eliminate that issue is to get a survey. And sometimes they have to go to court because the other owner says, well, hey, you know what? The prior owner allowed me to put the fence there. And so I can access this land that's on the boundary line of my fence, but it actually does not belong to them. And that owner is no longer there. So now we have a new owner. That fence needs to be moved. And some individuals, that have been using it for years will want to call it theirs. Well, it is not. And it'll show up on the survey. Emblements. What are emblements? Annual crops considered personal property of the tenant. So many landowners that when there were a lot of agriculture being grown, cotton, corn, cabbage, sugar cane, all types of different products, right? Wheat and hay. So those are emblements. If a person is leasing the land, so those emblements, which are the crop, belong to the lessee, but the land belongs to the lessor, to the owner, and they are leasing the land to a farmer. It's less expensive for a farmer to lease the land than it is to purchase the whole acreage and own it for themselves, especially when, let's say, farming is becoming less and less. So the owner of the land ends up leasing this land, and a lot of times it's like $1,000 an acre. So if it's 20 acres, I'm sorry, not $1,000, like $100 an acre. I sold a lot of land in South Texas and in Oregon, and the owners will lease it for $100 an acre. You wonder, wow, that's not a lot of money, right? Well, they basically are having that lessee, that farmer, maintain their land, because that land has to be cleared after the crop, after they harvest the crop, and then row it again and plant new seeds. So the land is being maintained. So they basically want just enough money to pay their property taxes until they're ready to sell it. So those are emblements, annual crops considered personal property. Freehold estate. What is a freehold estate? It is ownership interest with indefinite duration. Well, that freehold estate is an individual that is having the right to use somebody else's property, okay, with a indefinite duration. It could be for the life of the individual, or it's the actual owner that owns the property and they have all the bundle of rights. So they have a freehold estate. If the owners allow someone else to live on the property, let's say a husband and wife, but the property belongs to the husband or to the wife, and they put in their will or their estate or their, what do you call it? A trust, okay? And it says that the spouse remaining will continue to utilize the property until they pass away. So no one can kick them out of that property. That's ownership interest with indefinite duration. Fee simple, absolute. All these terms are extremely important for property ownership. So fee simple absolute is most complete form of ownership. So it includes all the bundle of rights. Okay. So when we have the bundle of rights, here they have the ownership rights to possess, control, enjoy, exclude, and dispose. Okay. So that goes into a fee simple absolute, most complete form of ownership. Life estate. So it says life estate, an interest in property for the life. Okay. So ownership limited to someone's lifetime. Like I mentioned on freehold estate, ownership interest with indefinite duration. So that could be the owner or the owner giving somebody else a life estate. Ownership limited to someone else's lifetime. However, this life estate will include that that person cannot sell the property. They cannot encumber it, which means they cannot get a loan on it or lease it to somebody else unless it's in the described regulations, okay, of that owner, what that owner allows them to do. They might allow them to lease it while they go live somewhere else temporarily. However, that person is able to use that land for their lifetime until they pass away. Once they pass away, it returns back to the original owner. If that original owner is no longer living, then it goes to whatever the will says. Leasehold. So keep in mind, it says lease. They hold the lease interest on a property. So it is the right to occupy property under a lease. So a lease has a what? A starting point, a starting date, and an end date. So it's for a certain term, a certain time. It can be for a month and it's renewable for a year or multiple years. So if it's for a month, it can be a month lease and it's renewable. Most leases for residential, for rentals, or for a year, right? Some of them can be for 6 months, some for less, but it has to be specified in the lease. The same with leasing land. The land can be leased for crop. It can be leased just to put a manufactured home, an RV, or a business structure that can and eventually will be removed. And so it is a term lease and a right to occupy a property under a lease. Tenancy in common. This is one of the 4 different types of ownership for property. It's co-ownership with inheritable shares. So it's 2 or more individuals that own the property together. Doesn't mean they bought it at the same time or they owned it at the same time. And it doesn't have survivorship. That falls under a different type of ownership. Tenancy in common is the thing they have in common is the property, but it can be different percentages. It can be a 20-80, 30-70, 50-50. So that's what they have in common is the co-ownership of that property, and it is inheritable. So each of the owners, their heirs inherit their share. Joint tenancy. This is the one that's kind of like tenancy in common. However, it has to meet other conditions. So it is equal shares with right of survivorship. So on this, let's say there's 4 owners. Each one has 25%. They bought it at the same time. They closed and bought it at the same time. They have equal shares. They have right of survivorship. And they are all have full usage of the property. They have full enjoyment, full possession, not just the 25% that they own. They have full possession of the entire property. So it has to meet those 4 conditions, okay? Equal shares, purchased at the same time at the same title company, a right of survivorship, and full possession, 100% possession. So that is joint tenancy. It's 2 or more, okay, owners with equal shares. So it could be 2 with 50-50. Now, when one of them dies, their portion goes to the survivor of that joint tenancy. It doesn't go to their heirs. Like in tenancy in common, it's inheritable shares. Well, it's not inheritable shares in joint tenancy. It goes to the surviving tenant, which, you know, we call tenant not like a rental tenant. It's a joint ownership, and they call it tenancy, right? It is ownership of that property. Community property. So community property is similar to joint tenancy. No, I'm sorry. Tenancy by the entirety. In Texas, we have community property. In other states, we have tenancy by the entirety. So it is property acquired during marriage in Texas. If it is in another state that isn't using community property, then it's called ownership in entirety. Okay, so they own the property for the entirety, and they end up, when one partner dies, the other partner gets their share. It's called tenancy by the entirety. Separate property. Is it separate property or separate property? So separate property is owned before marriage or received by gift or inheritance. So any property that's owned prior to marriage belongs to the individual that owned it prior to marriage. If it was a property received by gift or inheritance, it belongs to that individual. It is separate property. It does not become community property, which is after marriage, or tenants by the entirety. So separate property remains separate. Now, there could be an instance, an exception, where this property is owned by one spouse or one individual. They don't have to be married. And the property is then used for rentals, or it is improved, it's remodeled. Any expense that goes into that property that comes from the joint relationship, from the marriage, then that portion becomes community property or tenants by the entirety. So if they're generating income on this property during the marriage, that income becomes joint income. That income becomes community property. It belongs to both, not the actual property itself. However, the income does, because the income is happening during the marriage. If they improve the property and they invest money from their joint account and both contributed, so a percentage of that property will be joint property. Condemnation. Condemnation is process of taking private land for public use. And who normally does this? So the community zoning, the state or the county or the city can take property under condemnation. If they're expanding a street and they need part of the frontage of some of the homes or the businesses, then they have access to that private land for public use. However, they need to present that and present a current market value offer to those owners in order to take control of that property. If the owners do not agree, then they can do what is called reverse condemnation or inverse condemnation, where they object to the offer that is being presented to them by the city, the county, or the state for public use. However, the state, the city, or the county, has a right to continue offering something else until they both come into agreement. As the cities are expanding and growing and population is growing, the substructure has to be improved. And it may require expanding streets to have more lanes, new, it can also be for irrigation rights, irrigation canals, for expressway, or things like that, that the city, the county, or the state needs in order to improve the substructure of the community. And the owners, yes, they can go against it with inverse condemnation. However, eventually it becomes part of the public use with a price that is paid that is satisfactory to the owner and also the government. Eminent domain. So the condemnation is the process of taking private property. Eminent domain, government power to take property with compensation. So first, it's eminent domain. The government has the power to take property with compensation. And if the owners don't agree, then they do condemnation. They condemn the property, kind of like when a property goes into foreclosure, the bank can condemn that property and take control. If a property is not being managed or maintained, the city or the county can condemn that property for no one to access it, because it could be, have public safety issues. And so they condemn the property. They'll post signs on it. Pardon me. Process. It's the government power to take property with compensation to use it to improve the city, the county, or the state. Agency. Agency represents a principal in transactions. So when we're representing owners or buyers or tenants, we have to have an agency relationship before we can represent them. And that can be a buyer's rep, tenant rep representation when we're dealing with a buyer or a tenant for a property. If we're going to help a seller sell the property, then it's a listing agreement. Okay, so the other one is first a buyer's rep agreement in order to present it, because as there were National Association of Realtor lawsuits, now before we can show any property nationwide, we have to get a buyer's representation agreement. At least that's what I know in the state of Texas, before we can now show property. And buyers have to be educated and understand that we as realtors will not show them property until there is a buyer tenant representation agreement signed. Then we can go and show them property. This becomes an agency. We're representing a principal. The principal in that case is the buyer or the tenant. If we're going to represent a seller, then it is a listing agreement, exclusive right to sell. It's the type that we want to use. There's different types of listing agreements that you should be aware of. Fiduciary duties. What are our fiduciary duties? So fiduciary duties are loyalty, obedience, disclosure, confidentiality, accounting, and care. So we must be loyal to our clients. We must be obedient to what they request us to do, as long as it's within the law and we're not breaking any rules. We must disclose that we are realtors or a broker, that we are an owner of the property that we're selling. We have to disclose. It is crucial. Confidentiality. During the agency agreement, we have to have confidentiality of that owner. Even after the relationship is ended, a transaction closes or a lease is completed, then the confidentiality still stays in place. Okay. Accounting of all activities and expenses that we deal with that client, with that agency relationship, and caring for them. So we have to be transparent, be honest, be direct. Those are some of the important issues that are asked by the real estate commissions, right? Being honest, being loyal in order to get a license after we take all the courses and we take the exams and before they permit us to become active realtors, or we go into an inactive position until we select a brokerage and then we become active realtors. So loyalty, obedience, disclosure, confidentiality remains even after a transaction is closed. Accounting and care. Listing agreement, as I just mentioned. What is it? It's a contract allowing broker to sell property. And since we are realtors under a broker umbrella, then we are the associate for the broker. The broker isn't necessarily the one that's doing the transaction. They are representing the client through the associate as a realtor. Now, in some states, the broker is actually the realtor, like in the state of Oregon. I had a license in Oregon. So in Oregon, we have the broker is what we call a sales agent or realtor. In Texas, the principal broker is what we would call a broker in Texas. They're the umbrella, the brokerage, or the person responsible for the realtors that hang their license with them. So it is a contract allowing the broker to sell property with it being actually represented by an associate, and the associate is the one that typically signs all the listing agreements and all other agreements that are required to be signed by a broker. So an exclusive right to sell, it's one of the types of listing agreements. A broker gets commission regardless of who finds the buyer. That is exclusive right to sell. That's the type of listings that we want to get and that you want to get and come to agreement with a seller. There's exclusive agency, which means, and we may discuss that, okay, but exclusive right to sell is that the broker gets paid commission whether the seller procures the buyer, finds the buyer, or the realtor attracts realtors to bring a buyer. Either way, the brokerage gets paid. Exclusive agency listing, that's the other type. So here the seller avoids commission if they find the buyer. We don't want to do this, okay? Our experience and our service has a cost. And it's important for us to charge, just like doctors, dentists, lawyers, contractors, on and on and on. They charge for a service. Our service is to help them sell their property. If we do an exclusive agency listing with a seller, then the seller finds the buyer, we get nothing. The broker gets nothing. So we just did all this work. We did all the marketing and advertising, but then the buyer comes directly to the owner and the owner sells it. But who do you think attracted those buyers? A lot of our marketing, because it goes on the MLS and it goes syndicated into tons and hundreds of websites. So they end up getting a lot of marketing without being required to compensate if the buyer goes directly to them. So we want to have an exclusive right to sell versus an exclusive agency. An open listing, just like the word says, it's open. So open listing is multiple brokers that the owner ends up using, but only the procuring broker gets paid. So this owner might say, well, hey, you know what? You bring me a buyer, I'll pay you whatever percentage we agree upon. And they say that to many brokers or many realtor associates of the brokerage. Well, only one is going to get paid because there can only be one written contract that is legal. So that's another thing. Majority of agencies and states do not accept open listings. And we don't want to do that. You don't want to do that. Now, there is an exception when we have repeat clients that we've done a lot of business with, and they don't want to put it on the market yet. Okay. But we have an agreement directly with them because we have done a lot of business with them. So in some instances, we might accept an open listing, but it's best to have an exclusive right to sell listing from the start, because your broker may not accept an open listing anyway. Buyer representation agreement. That is a contract where the broker represents the buyer. It could be the tenant. The buyer representation agreement in, I think, most states, or at least in Texas, includes buyer-tenant representation. Because in Texas, we can represent tenants that are looking to lease homes. In other states, there may not be. But we do here in the state of Texas. So it's a contract where broker represents the buyer or the tenant. Offer and acceptance. It's a mutual agreement to contract terms. So when a buyer finally decides on a property that their buyer agent is showing them out of many properties that they show, and hopefully only 3 to 5 properties a day. We want to put boundaries and limit how many properties we show a buyer, and we want to know exactly what that buyer is looking for, and that's through the buyer consultation appointment. It's find out exactly what they're looking for and make sure that they are pre-approved, right? Or connect them with a lender, because there are many buyers that many times can't pull the trigger and make a decision to buy, or it comes out to be that they do not get pre-approved for a loan. So it is at first, we find the property. Once that we have a pre-approval, we know they're what? Ready, willing, and able to buy, to purchase. And we write the offer after finding different properties that meet their needs, their requirements. Once the offer is presented to the listing broker or listing realtor, and they present to their seller, there may be negotiations going back and forth until an acceptance is made, until they come to a mutual agreement. So the offer is made first, and if there's any negotiation, if the buyer presents a lowball offer, then the seller may counter. So it could go back and forth, several counters, until there is an acceptance. Once there is an acceptance, means all parties have signed in the bottom line. And then it's taken to a title company or an attorney, which are the escrow. Consideration. So what are we considering? Consideration is something of value exchange. So when a buyer makes an offer to a seller, we're presenting some type of consideration. It does not have to be cash. So that consideration is considered earnest money if it is money that's being delivered to the title company or the other escrow officer, being an attorney. So, but it doesn't have to be money. It can be an exchange of a property. It can be a promissory note. However, it is an exchange of value. So the promissory note has a value saying, hey, I'll deliver the earnest money in 5 to 7 days after acceptance, or I'm sending the earnest money now, or I'm going to trade this property for your property. Those are all considerations. It does not have to be cash or money in a cashier's check or other form. Breach of contract. It does happen, but not as often as you might think. It's failure to perform contract terms. And these contract terms are the listing agreement, that's a contract, a buyer-seller agreement, which is in a 1 to 4 resale residential home contract, or commercial, or industrial, or land. So it's any of those contracts, or a tenant contract, a tenant lease. If one party fails to perform on the contract terms, the agreement, okay, that contract specifies on there what are the consequences. And so those are called specific performance that each party has to meet. And if they don't, there are consequences. Sometimes it could be losing your earnest money, or losing or the seller deciding not to sell. The buyer can take them to court, but that will encounter more expenses, right? Attorneys. A mortgage. What is a mortgage? A lien property for loan repayment. So whenever a buyer is looking to purchase a property, we're going to ask them, are you pre-approved with a lender? Because we want to make sure they're ready, willing, and able to purchase. So once they purchase, once there's an offer and a contract and it goes through closing, then there will be a mortgage, and that is the lender. So the lender will put a lien on the deed securing property for loan repayment. That will stay on that property on that deed, and until the property is paid, the loan payment is paid, or it is resold. And then the loan will be a lien release. Okay. And if for some reason they don't pay, then they're in default. Then there's other circumstances that come about, right? It could be a foreclosure or deed in lieu or a short sale, many other things that could come about. A deed of trust. There are at least 40 to 50% of the states do a deed of trust. Others do a mortgage. And the difference on them is the type of foreclosure that takes place. So with the deed of trust, think about it, a trust. Whenever there's a trust, there are three parties involved. So in Texas, it's a document with a borrower, a lender, and a trustee. The trustee is the person that the owner or the lender trusts to proceed with any type of action that is described in the deed of trust. If there is late payment, if there are no payment, if they need to go with a foreclosure. So it gives instructions. What happens if a lender sells the company? Then it sells the loan. It gives those instructions. And so with the deed of trust in the state of Texas, we have a non-judicial type of foreclosure. Non-judicial means that it doesn't have to go to the courthouse to get the judge's approval, get a judgment with the judge. It's already, the process for a foreclosure is already described in the deed of trust. It's a long document, lots of pages. A lien. What is a lien? A legal claim against a property for debt. So it could be a mortgage. It could be child support. It could be spousal support. It could be a mechanic lien, other type of judgment, property taxes that are due. So those are all considered liens, and they are attached to the property. So it's a legal claim against the property for debt. And there's a priority on these liens, and you want to learn what the priority is. The first one that has the majority priority are property taxes. Property taxes have to be paid before anything else. So a person can actually lose their property because of property taxes. So the city or the county can foreclose on that individual for property taxes. And there have been individuals who lose their property just because of the property taxes that they owe. They do have a right of redemption in the state of Texas. It is 2 years that they can redeem that property, pay the debt off, and interest on that debt from the person who ended up purchasing it at the courthouse. Foreclosure. Sale of property to satisfy unpaid debt. So there are two types of foreclosures: the non-judicial foreclosure that we have in Texas and in maybe 50% of the states, and then there's a judicial foreclosure. And the judicial, then it goes to court and request a judgment and get it approved by the judge in order to proceed with a foreclosure. Amortization. So it is a scheduled loan repayment of principal and interest. Whenever there's a mortgage that an individual gets from a mortgage broker, a lender, a bank, and they're getting a 10-year, 15-year, 20-year, 30-year, and now we might be going up to 50-year types of mortgages because of how our economy is right now. Then the payment for that loan is amortized. It's stretched out for the term of the mortgage. So typical for residential is 30 years. So it is stretched out for 30 years, and an amount is determined by dividing it by the 360 months, 30 years by 12, right? 360 months to determine what the monthly principal is and what the amount of interest is. And of course, the interest will be based on the current interest rate. If the and that is the annual percentage rate, okay, not just the interest rate, because there is a cost of borrowing money from the lender and a cost of closing that can be added to the mortgage amount and amortized for the term of the loan, be it 15, 20, 25, 30 years. So it is a schedule, so like a long spreadsheet that includes all the principal amounts, the interest amount, and what the balance will be every month. Now, the principal starts increasing. The more years have been paid, then we gain more principal, and that's where we gain equity. The interest amount starts to decrease. Initially, the interest is higher than the principal. As the years go by, then more money of the payment goes towards principal and less goes towards the interest. Equity. So as the years go by and we've paid a lot of principal, then we have equity. Or if the market appreciated, so it is value minus owed loan balance. It's the current market value minus the current owed loan balance. And equity can increase because the property or the market has appreciated and the property is now worth more than what it was originally purchased at. Now it can become negative equity, where we have some of that right now, where people are losing money because the market value has decreased and they owe more than what the current market value for that property can sell for. Appraisal. Whenever there's a loan involved, then there is an appraisal. It's a professional estimate of value. So it is done by an appraiser. An appraiser here in Texas is licensed by the Texas Real Estate Commission, but it's different than licensing a realtor or a broker. Because Texas Real Estate Commission also, there's an appraisal commission that licenses appraisers, not the Texas Real Estate Commission. Texas Real Estate Commission does realtors, brokers, property managers, inspectors, easement individuals. Appraisals is by a different commission. And that appraiser does a professional estimate of value. Now, we as realtors, we also do an estimate of value, which is called a comparative market analysis, a CMA. So we can do that for a seller. We can do that for a buyer. It's for a seller. We call it also a CMA, but it's a competitive market analysis, which includes actives, pendings, and sold. A comparative market analysis only includes sold. We just want to know, what did a property sold for? And that's what an appraiser is going to look at. What did properties within a certain area from the subject property, how much did they sell for? That's what they care about. Market value. Price a willing buyer and seller agree upon. So when we think of, well, what is the market value? My property is worth, $1 million. Well, a buyer may not pay that for your property. So it's going to depend on today's current market value. And the actual market value is determined by the agreement that that seller and buyer come to. So it has to be a mutual agreement between the seller and the buyer. What they agree upon and they sign contracts for, that is the current market value. Even though the appraisal might be higher or the appraisal might be lower, it's what the buyer and seller agree upon becomes the current market value for that property. Highest and best use. It's more profitable legal use of the property. So what is the highest, best use of a piece of land? What is the highest and best use of this residential property? So it is the most profitable, the property that'll make the most money use of that property. So a commercial property along the expressway will have more value. The highest and best use of that property is to sell it as commercial, right? Because it's right in front of the expressway, not sell it for residential. If somebody tries to sell it for residential, it's going to have a much lower value because the surrounding properties are commercial and it's in front of a expressway. So the best use, highest use of that property is to sell it as commercial. And sometimes it will have a higher value if two lots are combined versus just one and buying them separate, because it may require, let's say for some of the drive-through companies, right? Like McDonald's, Burger King, and Subway, Pizza Hut, a lot of other companies, right? Or huge department stores. They might need more land. So if an individual has multiple lots that they own along the expressway, okay, they will want to combine those parcels, and it actually will increase the value because someone like Walmart or Home Depot wants a larger piece of land, and they will be willing to pay more for the larger piece than buying two separate small lots. So finding out what is the highest and best use of a particular property, which one is going to be more profitable. All right, CMA. We just talked about CMA, right? Comparative market analysis. So that is a broker's estimate, broker, realtor, associate, using comparable properties. Those comparable properties, depending on how the current market is, if it's a fast changing market and prices are changing rapidly, then it could be within 1 month, 3 months. Typical is a 6-month range, and that's what also appraisers will use. So in a regular, more stable market, then we use 6 months of properties that have sold to compare with the subject property. The subject property is the property in question to be sold or to be purchased. And we can do this comparative market analysis for sellers to determine a list price, or for buyers to determine what kind of offer they should make. And the competitive market analysis we will do for a seller to show them also some of the pending properties and some of the active, which is their competition. Okay, so our last term for tonight is title. What is title? Evidence of ownership. So the title of a property is proof, it's evidence of ownership. And the deed has also description, property description, and who the owners are. But the title, which the title companies will also issue, is the actual evidence of ownership. Okay, so that's not sure how many vocabulary we did. It was quite a few. So I hope this helps you in preparing for your real estate exam. These vocabularies are crucial for you to prepare yourself to answer the questions correctly. And so make sure you study and review as much vocabulary as possible to prepare you to answer the questions and understand what the Texas or national questions are asking for. And because you will also see a lot of the vocabulary, not only in the questions, but also in the answers. It'll help you be able to decide on the answer much quicker when you are familiar or understand more the vocabulary than what you don't. Now, is it the only thing you need in order to pass a real estate exam? No. You need to understand the concepts. You need to be able to answer questions correctly. And how do you do that? By practicing more and more and more questions, and repeat the same questions over and over until you get 100 score in real estate practice exams. So some of my videos go over particular questions that pertain to Texas and also to national. And so I highly recommend that those questions in any of the books, prep book that you buy from any state, it'll have your national questions, which are the same for all 50 states. And then there are particular questions for the particular state that you are taking the exams for, in this case, Texas, because I am in Texas and I am an active realtor representing sellers and buyers. So learn the vocabulary. I can't say it enough times. And there are many areas that you can download vocabulary for free and review it on your own. On the internet, there's so much available. With ChatGPT, with AI, you can get vocabulary, you can get questions, but make sure you review them, because ChatGPT is called that it hallucinates. Okay. And so there are errors. Just like humans, we make errors, so does AI. So you have to confirm that the answers that are provided by AI are correct. So hopefully you enjoy this and you continue to practice your questions and answers and vocabulary. I have many, many videos that you can watch next, okay, on the playlist that I have having to do with Texas, national, vocabulary, combination of Texas and national questions, and some concepts. So please review a lot of my other videos so that it'll help you prepare for the exam. And when you're done with practicing and studying and taking your exam, then we can talk about the next step, which will be how to choose a real estate company, which I do have a video on that, and selecting the brokers that you want to go to and work with. Make sure you ask a lot of questions. But for now, study, schedule, be committed, be consistent, do it every day, especially a week before the test. Make sure you practice and study every day. Find study groups that you can do this with, and study with other individuals, unless you prefer just to study on your own. Everybody learns in a different way. So enough for tonight. This is Lily Handy Dominguez coming to you from San Antonio with YouTube AgentPrep. I've been doing this since 2014 on YouTube, since 2020. So there are a lot of videos. I do have a Facebook group called Facebook group is a private AgentPrep real estate group that you can access some resources on there. And I also post on there when I am doing a live. Unfortunately, today I had challenges, so I started a little bit later. So if you have any questions, post on the comments what you would like me to review and what you need help with. And I will answer the questions. And when you're done and passing your exam, let's talk about selecting a real estate brokerage. Maybe you will select eXp Realty and join me at eXp Realty. Until next time, catch you later. Remember to say, I passed, and I passed, and you will. Until next time.